name is Bridget Mackay, and if you're watching this, you may already be a follower of my blogs, or if not, these are blogs that I do that give some good information for people on estate planning, probate, and various other subjects. Today I want to talk about changes in the law for 2012. There were two changes that were significant for Californians this year. The first is with probate code 13,100. You don't have to remember that, or the fact that it was State Assembly Bill 1305. What you do need to remember is that typically in a probate, and if you have questions about probates, you can look at other videos I've done. When you die, if your assets, gross assets totaled over $100,000, that would trigger probate. However, if they were under $100,000 at your death, you did not have to go to probate, and you could go through a petition process under this code section that changed. That was the law from 1996 until 2012. The State Assembly raised that bar to $150,000. Most of you out there, if you own real property or have assets over, or you think you may have assets over $150,000, you most likely will want to get a trust. However, those of you who have loved ones who have passed away and they didn't own very much and had under $150,000 in assets at their death, you can transfer those assets without ever having to go to court. So it was a very good jump in amount. The second also deals with small estates, but it applies specifically to real property, things you own. You know, typically houses in California are going to be far over this amount, but it used to be you could transfer a real property that had value under $20,000 without having to go to probate. Now they have raised that amount to $50,000. You ask, what does that apply to? Well, like I said, if you have your own home, this is not for you. But if you have a loved one who died and had some real property, maybe fractional interests in real estate, timeshares, most common I see are mineral rights, things like that that total under $50,000 in value, but because they're real property would have normally sent them off to probate, now doesn't have to go through that route. There is a court filing you have to make, but it's much, much more streamlined and less of a hassle of a process than probate is. So those are two really good changes in the law that increase your ability or your loved one's ability to get property transferred when you're dealing with a small estate with as less court involvement as possible. So if you have any further questions or you're in this situation, talk to your attorney about these changes in the law. It could speed up your process a lot more and make it a little less painful when you're transferring.